Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law Section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law Section. My name is John Roberti, and today's topic is, do you really know all 54? Understanding competition law in Africa. Africa is becoming an increasingly important area for competition law. But what's really important to remember is there isn't just one Africa. Africa is made up of independent enforcers who assert their independence, and they all are going to want to make sure that the competition laws in their particular jurisdiction are being adhered to. Today, we're going to speak to a few experts and learn more about understanding and navigating competition law in Africa. My co-host today is Matthew Hall. Hi, Matthew.
Hi, John. It's very good to be back.
That's always a pleasure. So, Matthew, what are we doing today?
Well, as you said, John, we're looking at competition or antitrust law in Africa. We're going to look at the trends and themes on this subject on a continental level, with looking at anecdotes from various countries to illustrate how things are working in practice. And specifically, we're going to have input, we're honored to have input from the head of the COMESA Competition Commission on these issues.
Matthew, who are our guests?
Well, as I mentioned just now, we're honored to have George Lipimile. He is Director and Chief Executive Officer of the COMESA Competition Commission. For those who don't know, COMESA is the common market for Eastern and Southern Africa, a grouping of 21 African states. And the Competition Commission is responsible for enforcement of COMESA's competition law, which operates in parallel with the national laws in those member states. As you mentioned, John, there are also national laws. But COMESA focuses on cross-border transactions within that state grouping. It started operations in January 2013, and George has held his current post since then. Overall, he has more than 30 years of experience in competition law and policy enforcement. Hello and welcome, George.
Good afternoon, and thank you.
And we also have Jocelyn Katz. She's a South African lawyer and head of ENSafrica's Competition and Antitrust Department. She specializes in all aspects of competition law, including mergers and complaint proceedings involving prohibited practices and abuses of dominance. Hello, Jocelyn.
Hello, Matthew. Hello, John. Lovely to be here.
Well, thank you very much again, both, for joining us. Jocelyn, I just wanted to start off with a brief introduction. John mentioned the continental situation in Africa. Could you just give us a bit of background, a bit more detail of what we have in Africa, both at the national and supranational level?
Yes, sure. So as John mentioned, Africa is not a village, so to speak. Africa is made up of, according to the UN, 54 different countries. In fact, we have 56 on our list that we track because we include Western Sahara and Zanzibar. But nonetheless, many of these jurisdictions have their own domestic legislation. So at today's count, since Niger has just come on stream, 46 of the jurisdictions have their own domestic legislation. If you include those that have draft competition legislation, that number goes up to 51. So, in fact, almost all African countries now have their own domestic legislation. But in addition to that, there are, as you rightly pointed out, a number of what we call regional bodies or supranational bodies. There are 5, the most predominant one of which is COMESA, and George will, I'm sure, talk a lot about that. But there is also the EAC, which is the Eastern African Community, the Western African Economic and Monetary Union, known as WAEMU. There is the Economic Community of Central African States, known as CEMAC, and then ECOWAS, which is the Economic Community of Western African States. So, of course, there's a large degree of overlap between the national regulators and the regional bodies, and not all of the issues regarding sort of whether or not they're a one-stop shop in all cases has been resolved, which is not unlike other jurisdictions. But essentially, each of the African countries has their own market structure, has their own specific local characteristics, and certainly their own rules and developing jurisprudence.
That's very useful, Jocelyn. So it's quite an incredible jigsaw in that vast jurisdiction of 54 or 56 countries. In recent months, of course, we've had the COVID crisis worldwide. It has impacted, of course, African jurisdictions and competition law in Africa. How have the authorities responded to that particular issue?
Thanks, Matthew. So yes, indeed, in Africa, the socioeconomic impact of COVID has been immense. It's not surprising that many of the regulators across the continent have taken steps, well, where they can, to utilize competition policy and, in fact, all available regulatory tools to mitigate the damage. So, they've done various things. They've responded by prioritizing COVID-related complaints. We've had a lot of that here in South Africa and elsewhere. Investigating price increases in various sectors, enacting price gouging regulations, prosecuting firms for pricing, particularly on essential goods, sanitizers, face masks, things like that. They've entered into large numbers, particularly here in South Africa, once again, of settlement agreements, and also sought to intervene on a sort of mediating basis with various industries. So maybe just to delve into a little bit of the detail, some of the countries have gone about relaxing some laws in relation to cartels, allowing companies to collaborate really with the end of fighting COVID. So, for example, in Egypt, in Nigeria, in Mauritius, they've issued notices acknowledging that competitor collaboration could potentially be necessary in certain circumstances and provided guidance on how to go about that. Similarly, in South Africa, we had block exemption regulations issued for a number of industries, the healthcare industry, the banking industry, the hotel industry, really enabling coordinated conduct for the benefit of consumers during the period of national disaster, which we're still in, incidentally. There have been a number of prosecutions, particularly of price gouging, which was not necessarily, in all cases part of the law, but has been incorporated either by, through sort of case law prosecution or in South Africa in particular, there was a particular regulation passed and a number of matters prosecuted. In fact, I think at last count, the competition authorities here have signed 34 settlement agreements. The downside is that they were promulgated under the sort of dominance provisions in the Competition Act. And so it's led to this fairly absurd outcome where new entrants into some of these markets have been found guilty of abuses of dominance, or at least have conceded that they are guilty of abuses of dominance. We've only actually had two parties fight it, and both have in fact been found guilty, one of which is taking the matter to appeal on the 4th of September. So we'll be watching that quite closely, but it has led to a little bit of an absurdity in our jurisprudence. There are other countries that have sought to investigate, Malawi, Nigeria. In fact, Malawi has looked into hikes in their transport fare hikes and things like that. So there's been a vast array of interference, shall we say, from authorities in order to try and combat the array of issues arising out of COVID, from the sort of pricing of sensitive goods or essential goods, the need to collaborate.
Thanks, Jocelyn. I mean, I think that's very interesting for a number of reasons. For me, at least, I think what it shows, it's a great introduction. It shows us that the laws in a number of countries are fairly recognizable from the EU, US, UK point of view. You're referring to abuse of dominance provisions. You're referring to anti-competitive agreements. And these, of course, these types of issues have also arisen in the COVID crisis in the EU, UK, and US. So it looks like a lot of the same issues have been grappled with. Is that really what we're seeing?
Absolutely. But I think the one sort of takeaway is that a lot of the impetus for these things, primarily arises in the African context out of the socioeconomic impact as opposed to, the consequential impact on socioeconomic issues rather than on competition issues.
Right. Yeah, I'd like to hold that thought. I guess we'll probably come back to that when we look at merger control in a few minutes. But that's a very specific issue, as I understand it, in many of these regimes. I'd like to turn to George, please. George, staying on COVID response for a moment. As we said, you're responsible for the COMESA competition law, looking at 21 African states. So you must have a pretty wide overview of what's been going on in this particular regard concerning COVID.
Yes, Matthew. You see, when COVID started, it was a distance call from China. So most of the countries didn't expect the effect to be so strong in their territories. So when it landed in Africa, when we started experiencing the effect of COVID-19, most countries didn't know what to do. It was wait and see, or what is the neighbor doing? So the reaction was double-fold. Some countries' response was more of an economical response. Some countries, it was what we may call a political response. And there was an outcry of most of the stakeholders blaming their governments that they are doing nothing to combat this COVID-19. Hence, it became more of a political issue than an economical issue. Most of our governments quickly set up what they called national task forces to deal with the whole aspect of COVID-19. But one feature which was very prominent was that most of these national task forces didn't take into account competition experts or competition issues in formulation of their terms of reference. So we can say that the first approach ignored or displaced their competition. Some of our member states, they didn't know which laws to use because they didn't have a legal framework to deal with the effects of COVID-19. Consequently, some member states came with what we say something akin to state of emergency laws to give a leeway to the task force and to the government to put in sanctions such as lockdown. But even the lockdown itself, what they termed as lockdown, was not so clear of what the people were expected to do, especially the business community. They didn't know how they were going to operate under the lockdown. Did it mean shutting off the streets, shutting off businesses, restrictions on movements? So nobody knew. In the countries like Malawi, the civil society went to court and got an injunction that the measures which have been put in place, they don't take into account the poor of the society. So again, there were legal battles. So by having a state of emergency, it gave the government a leeway to set aside competition rules. So the governments determined how business to COVID-related products should be done. Apart from that, the donor community came in and gave a lot of donations in terms of material and financial. So the business was left in a dilemma. Whereas you have got the products which you can sell at a competitive price, during the COVID-19 era, the government was distributing the same product at a subsidized price or free of charge. Apart from that, new legislation came in about custom free of certain products which were meant to combat the COVID-19. So all these measures, when they were taking place, we find that business was left to deal with the matters without any proper regulatory framework. So we tried as a competition authority to remind the government that they should take care of not liquidating their private companies, especially the private sector, because the private sector was complaining. And the duty-free window allowed the traders to take advantage of that. The demand was high in certain products like sanitizers, gloves, and so forth. So when the demand became high, of course, it was a law of supply and demand. The prices went up. And the reaction of government, since it was not well coordinated, it really affected the decision, affected the market. So there was no fair play on the market. The donors themselves contributed to this because the donors were not the donations were not coordinated. You open the newspaper, you find that such and such international donor has donated so much material to a certain group. And these donations easily, because of corruption and the dishonesty, trade practices, found themselves in the trading chain. And again, it disadvantaged the honest trader. So that was not taken into account. And on the choice, that was very important, of people to deal with this COVID-19. The choice was not transparent. It was left for the politicians to appoint, like if there is a quarantine, which hotels or which places would people be quarantined at? So all those brought a lot of issues. The tender systems, competitive tender systems were broken down. There wasn't anything like that. There were no adverts. So everything was done by the public officers. The distribution systems also, you do recall, maybe you heard that certain borders couldn't allow trucks to move to distribute their goods and services. There were long queues because governments didn't know how to react. Each country was accusing the other that the COVID is coming from this country. I go to an example which came out in the media was Tanzania. It refused to accept that there was COVID. So to them, it was business as usual. So the reaction was it was not very, it didn't take competition, address competition issues. Even the competition authorities, those which tried to find that they was mostly dealing with consumer issues per se, rather than competition issues. Because
George, I think that's a great description of what's been going on. Can I ask, looking to the future, do you think that what has happened, that type of activity which you've been discussing, will have an impact and set back the advance of competition law in COMESA or the individual countries? Or do you think that once COVID has hopefully passed and is in the background, the advance of competition law enforcement will continue or go back to normal? Is there a permanent scar from this on the competition law side of things?
No matter, I would think this is temporal, because apart from all these anti-competitive practices, certain areas of competition law enforcement remained intact. As you mentioned, the major control provisions were not hardly or badly affected. There was 2 notifications, and the competitive analysis was taking place. And if we're moving forward, competition authorities also were undergoing a learning curve how to deal with a crisis like COVID-19. The situation now is stabilizing. We are finding the competition authorities now coming in and able to talk to their governments, especially on the issues I mentioned, like having the tender systems to start operating again, the distribution systems, the sourcing of supply so that it is done in an ordered manner. Slowly it is coming because the panic, slowly we are going above that, the panic which persisted at the time. You heard that certain lockdown measures were they really affected our businesses, but governments are going around to trying to lift some of the measures, and because there are no justification, some of the measures are no justification, but government was learning, so were competition authorities.
Okay, that is good to hear. I'm pleased to hear that the competition rules have not been permanently set aside. You mentioned merger control. I'd like to turn to that topic in a bit more detail. A lot of worldwide practitioners probably, when they think of Africa antitrust, they think of merger control first, probably incorrectly, but that's often our touch with the jurisdictions there. I'd like to turn to Jocelyn again, please. Jocelyn, merger control in Africa, 54, 56 jurisdictions. So there's a lot to talk about, but can you just give us a bit of flavor and some examples of what it looks like from your point of view?
Sure, thanks, Matthew. And I think that what George said is very interesting in terms of the the harm that I think no doubt COVID has brought. I do think is going to continue to shape the merger space in the sense that you'll be aware that what is often referred to, certainly in the US, as hipster antitrust approach is very much mainstream in South Africa and increasingly in Africa. And that is that a merger is not looked at solely on the basis of the competition law impacts, the economic effects. There has for a very long time been a standalone public interest assessment that needs to accompany the filing. And that is, it looks at things like the impact of the transaction on employment, on local ownership, on local suppliers, local distribution networks. And it's a much broader assessment than just the competition impact. I think that was the trend pre-COVID anyway across Africa. And there's no doubt in my mind, given what we've experienced in COVID, that's only going to be increased. We've recently had a decision out of Kenya, for example, where the Kenyan tribunal handed down a decision in a matter that entailed the review of various conditions, public interest conditions imposed by their competition authority. And I think we're going to be seeing more and more of that. I think the important thing to note about Africa is that each of these regimes has, is at a different point in their journey. So, for example, in Nigeria, we've only just had last year the codification of standalone competition law in their FCCP Act, which doesn't mean that they haven't had competition law. It was just incorporated in other laws, but it is now operational and it is running. And as the regimes develop and mature, they sort of increase in sophistication and complexity. We see a lot of them starting to monitor the business press for merger activity and call for filings, things like that. And there's also an increasing degree of cooperation between the authorities across the different jurisdictions. So certainly there is increasing activity. Had you asked me these questions 5 years ago, I would have told you there were probably 10 or 15 regimes that had standalone domestic legislation. It certainly has ramped up rapidly over the past few years.
Yeah, okay. And I think that the point you started with there on the particular public interest rules is so important when we think about merger control in Africa. George, COMESA is, I think it's fair to say, without doubt, the leading supranational body in Africa. It receives, I know, a lot of merger filings. What is your view on the trends and themes at a COMESA or a member state within COMESA level in relation to merger control generally?
Thank you, Matthew. You have to accept that the effectiveness of a regional regime depends also on the effectiveness of the national competition authorities, because we have got a lot of what I may call concurrent jurisdiction in most of the matters. And if you look at the major control regulations of COMESA, they call upon the member states to play a very active role, simply because by the time we arrive at the decision, there's what we may say in the courts, consensus in all the member states that this decision takes into account or takes on board, first, the competition issues, and secondly, the interest of almost every member state affected by a given measure. But what had happened during the COVID-19, there was a bit of the need to adjust our procedures. As if you look at the laws, we've got timelines in which to carry out certain processes. So we had to put up a gazette notice relaxing the laws on a time to file in and time to supply information or to give information to the commission, simply because it was not only the parties who had these challenges, but even the law firms, because most of the law firms were working at home, some were working at 50%, and information gathering became a problem. Our usual source of information, you find that they were working from home. They didn't have access to the databases to assist us with information. So times were sort of extended from the time we receive our application, the filing, and to the time we are expected to finish the assessment and to make a decision. So normally a decision was required to be made in 120 days. But we extended that to almost 180 days to allow the necessary consultation to be complete. And the method of analysis of the measure will base mostly on the EU systems. Because if you look at the laws in our member states and the laws at COMESA at regional level, they are basically based on the EU system. So we take a lot of precedents and the procedures and the processes which have been developed over the years by the EU competition authority. And our member states, again, you should know that the enforcement varies from one member state to the other. Some member states, they've got the law, but they've got no competition authorities to enforce that law. Some have got the law and the enforcement authorities, but the enforcement authorities are still very weak. They lack the capacity. So again, we've got to go down up to national level and try to look at the issues which are at play at national level before we look at regional level. So most of our member states, especially if I may say not only the member states, but Africa, they all, you can count on your hands, you can count how many, what we may say, effective competition authorities. The majority of the competition authorities, they still need technical assistance and they are still require a lot of assistance to analyze complex competition issues, so to say even the measures. So we've continued assisting these member states in capacity building issues, and the cooperating partners have been very good in assisting. And we've called also the law firms, the practitioners in competition, to come to our workshops, to come and give practical lessons on how, say, for instance, how to make an assessment of the measure, how to define the market, how to look at the barriers, and how to deal with public interest issues. Public interest issues in developing countries are very key because they make the law become necessary or become useful, not only to the consumer but to governments. And when you are dealing with the countries at the various stages of development, you have to be careful because a measure to some other country to be a key investment to that country. In another
George, I want
country,
to ask you about that particular point, if I could, the public interest issue, which, as you say, is very national focused, whether it be employment or whatever. And how does that fit into the COMESA merger analysis? If you're doing a filing at COMESA level, how do you take into account, if at all, public interest and issues at individual member states or indeed across COMESA as a whole?
Yes, Matthew, you see, public interest is embedded in our law and it is defined, and the law gives the issues you should take into account, which define public interest. But you observe that most of those issues which are in our law, they are also common at national laws. All the national laws of our member states, they also take into account public interest. You mentioned employment, it's very key. When we are making an assessment of the measure, you have countries like Zambia, which at a national level, every measure before it is approved, they've got to take it to a labor organization, which is a national labor organization, to look at it. And I think that is the style of South Africa as well. And if you look at the Malawi competition law, it also has got the same provisions where we have to look. So, in short, public interest is one of the defense where you can justify your measure, or it is one of an area where your application for a measure can be objected. So how do we approach this? To strike the balance, we go into undertakings to address issues which may affect the public interest of a given country. I'll give you an example, some of the things which are raised by the member states, because every time we receive a filing of the measure, we've got to inform all the affected member states of the measure and hear their objections. So the first response we get, it is more on the line of rejecting the measure. But you find in other member states, especially to whom the measure will be very adventurous, it will be a big investment, pushing us to accept the measure. So we look at those objections based on public interest, and we look whether they will substantially lessen competition in the common market. A good example, I know one application which involved the banking, because the new bank, they were saying it should continue with all the branches, it shouldn't be closing of the branches. And some of those branches which were at play, they were a branch of only 3 workers. In a farming area, you find this bank at more or less like a depot, where the farmers, after they sell their produce, they go and bank their money there. There were no banking activities apart from receiving money from the farmers. And when you look at labor issues, it was affected only 2 or 3 people at very low level. So all those issues, we go into it. But the important thing is that we cannot ignore public interest issues. They are very key to our analysis of the measure.
That's a great insight. I think that also, I think as a note is that when you're filing in COMESA, it sounds like you certainly need to go around, certainly with a difficult case, you need to go around individual member states and probably lobby in those countries, or at least work out their particular concerns. I'd like to move to
you can go around lobbying, but you see, mostly you get those responses from, if you are a lawyer, from the parties. They will be able to tell you what their investment in each particular country, where they were trading, what it means to that country. We are dealing with multinationals. And when it comes to simple things like tax compliance, they contribute a substantial amount of money to their respective government treasury in forms of taxes. So on that score, you find that the parties have got an advantage, especially if they put their claims, their justification, if very well, that they will be acceptable in most instances. They become acceptable. As I said, that you see certain countries are too small that the contribution to revenue by Coca-Cola becomes very substantial. So they would like that investment to remain in their respective countries and that investment to exit the market because of non-approval of the measure.
Right,
so
makes a lot of sense.
Undertakings, they tend to balance the market workings or the market operations.
Makes a lot of sense. I'd like to move to our final topic, substantive topic, very briefly. Jocelyn, cartel enforcement. We've already mentioned enforcement in relation to the COVID crisis, but looking at it more generally, could you give us a similar overview in relation to what this looks like in Africa?
Sure. So, look, other than in South Africa, large-scale cartel enforcement activities in Africa has been fairly limited. There was some, certainly in 2019. A lot of it came to a bit of a halt other than the COVID stuff that we've spoken about this year. But certainly last year, the Namibian Authority had 2 settlement agreements with insurance companies. The Mauritian Authority had fines against 2 chemical fertilizer companies, all for horizontal conduct. And there's at least one other active investigation that I'm aware of. Apparently, although it's not 100% confirmed, Egypt and Morocco have begun investigations on cartels. And certainly the president of Kenya has called upon the CAC, the Competition Authority of Kenya, to increase its enforcement activities. And as I mentioned, certainly the Malawian authorities are busy with a cartel, or I may not have mentioned it yet, in relation to online learning program fees. For a price fixing complaint, obviously that has arisen specifically in COVID. But certainly there is a trend, and they are conducting dawn raids in many jurisdictions. So they're looking for cartel conduct. We've had dawn raids in Kenya, in Namibia, Zambia, Tanzania, Egypt. So there certainly is movement in that regard. And there is also a move in a number of jurisdictions to criminalize cartel conduct. It has recently become criminalized in South Africa, although we're waiting for our first prosecution. But there are a number of long-running cartels in South Africa that are fairly active, fairly large fines. I think the longest running is the milling cartel that's been running since 2007, and I think we've just had almost the final or the penultimate settlement, which is the 13th or the 14th player has just signed their settlement agreement in that. So certainly there's a lot of activity in South Africa and increasingly into Africa, and I think we can expect to see criminalization of cartel conduct across the continent going forward.
George, I'd like to turn briefly to ask George about the COMESA situation. I know COMESA itself is responsible only, as I understand it, for cross-border issues, so presumably cross-border cartels. It's looked at very simply, is it a split, George, between COMESA cartel enforcement and national enforcement where that is done? How does it work in this area from your point of view as the head of the COMESA Competition Commission?
Yes, Matthew. When you come to cartel, fight against the cartel, we've been pondering on this issue for the past 6 or 7 years now. We have got readiness programs now running at the national level. Egypt have got a readiness program, Zambia, Kenya, and Mauritius. And they haven't been very successful if we compare to, in terms of fighting cartels, like the success with South Africa they had. So we've been working with the World Bank. The program is running right now to come up with a region-wide cartel program in form of a regional readiness policy program. We've got some consultants who are working on this program to give it a legal framework, and this will will give guidance to the member states and ourselves. Apart from that, we've got again with the World Bank, there are consultants working on the screening for competition selected markets in COMESA. Certain sectors have been selected, such as the construction market. But the major question to ask is, we've got cartels which have been busted by South African competition authorities. And you find that most of these companies who have been fined guilt of running cartels on the market of South Africa, they are also operating COMESA member states. You know, COMESA trade has about 60-70% of its trading patronage in South Africa. So you find the companies like in fertilizer, in construction, in bread, in poultry, they are all operating as subsidiaries in COMESA member states. Now the question is that, are they only flouting the laws in South Africa, and when they come to the member states, they are holding? So we are looking at that question to look at what the matters, the violation which they've committed in South Africa, whether those violations have extended to the COMESA member states, which I think the answer is 98% yes. Now the next question is, how do we stop it? And those are some of the issues which the consultants have got to advise us on. But otherwise, it's a very fundamental, it has become very fundamental and important that we come up with a region-wide leniency policy, which will deal with cartels operating at regional level. And depending on its success, I think this will go a long way to deal with cartels and maybe complement South Africa. Because there is a feeling that most of the cartel players, the major players, they've just gone across the border and continued their activities in the neighboring countries, especially where competition law enforcement is very weak. And whatever they are doing outside, it is affecting the South African market as well again. So we've got to collaborate with South Africa. Only that the good news is that we are now coming up with a tripartite competition regime, which will consist of the East African community, the SADC community, and the COMESA community. So we have only one competition authority. The model of the competition authority, which will come after the discussion, we are not yet sure. But this will be very effective to deal with the cartels in the southern region of, Africa, because it will be a wider market, and in terms of expertise, it will attract a lot of people who are knowledgeable, and it will be easier to deal with cartels. Thank you.
So it sounds like there's a clear message there to Jocelyn and other South African lawyers and indeed companies that if you find something in South Africa, you should be looking more widely in the region to see what else is going on within the company. I think you said they reckon that 98% of cartels are also going on outside South Africa, which seems an extraordinary percentage.
Yeah, Matthew, it's remarkable. It's the story we hear globally that cartels really don't respect borders. And, like so many cartels we look at in our U.S. and European practices, what looks like it might be a problem in one regime actually rarely is. They travel well. Well, this has been a really, really great discussion. I think we want to turn now to a section where we try to get to know the guests a little bit. And Jocelyn, we're going to start with you. Tell us something interesting about yourself that we wouldn't know if we only knew you professionally.
Something interesting, maybe. I hope it's interesting. I am a licensed scuba diver, and I have done scuba diving all over the world, actually, where I travel, but I do it in a very exotic locations where I can. But before I had kids, I took part in a Guinness Book of Records event for the number of scuba divers in the sea at one time, the largest number of scuba divers in the sea at one time. And it was in the middle of winter in KZN, and we got snowed in South Africa, which is a very rare thing in the Natal coast, and we couldn't leave. We did complete the dive and we did make the Guinness Book of Records, but that is something that...
So that's true dedication. How is it that you get on the list of people that say, hey, we want to do a Guinness Book of World Records with the most dives around the world? How do you get on that list? How do you get to be in that?
John, I can't remember. All I can remember was that I was part of this really committed dive school that went across the country doing whatever sort of dive events they could do, and they came up with it. They weren't invited. It was their idea to go for this record, which I think had never, in fact, been done before. In fact, I don't know if it's been beaten since, but it was sort of their concept, and I sort of tagged along.
Interesting. George, how about you? Tell us something interesting about yourself that we wouldn't know if we only knew you professionally.
Oh, well, I didn't expect this, but I think most people, what they don't know is that I'm a lover for music. That during my university days, I used to be a DJ. And now I'm planning to retire. And my pastime, although quite at an old age, is once in a while to be a guest DJ in some of the establishments which I used to patronize during my hair time. Only that I got to do a bit of practice of rap and know the latest disco equipment, how it works. But last New Year, I was in the Livingstone at Fairmount nightclub, and I was invited to do a bit of DJing, and I liked it. I thought, well, when I retire, I'll be visiting you. Maybe every New Year's there, and we will give you all these. So that is something which I keep to myself now.
Well, unfortunately, now all of our listeners will know about that. Have you considered your DJ name?
I used to have a name, but I won't tell you. Of course, I was a DJ, so I had a name.
So, and we're happy to help you to come up with a good DJ name. Okay, let's go to our final segment. We call the Curious Hat.
And now it's time for the Curious Hat.
So in normal times, we have a hat and people pull a question out of the hat, and that's the question they have to answer. In these times when we are not together, I have a list of questions numbered from 1 to 25, and I will ask you the question that corresponds with that number. Jocelyn, why don't you go first? Choose a number between 1 and 25.
I will choose number 40.
14. Okay. If you couldn't live in the country where you live now, what country would you like to live in?
That's a tough one. I would live, assuming I didn't have to make a living, I would live in the Seychelles, actually. I would obviously do scuba diving, and I would grow breadfruit, which is an amazing sort of starchy fruit that grows on the trees in the Seychelles, and that's what I would do.
Okay, Seychelles, diving, breadfruit. George, how about you? Can you pick a number between 1 and 25?
12.
Okay. Do you have any networking tips or particular ways you enjoy keeping in touch with those you've met during your career?
Mostly it is through emails and doing joint projects, because I like writing, and then I spend most of my time, those people I've met, asking them about the subject matter and what they think. Just giving opinions with those people and hearing their opinions on different subject matters.
And maybe in the future, we'll do some online DJing. But I think that's all the time we have for today. Thank you, everybody, for listening, and we'll see you next time on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.